Hi, Richard Pennington here again. You know, over the past few years now, there's been increased attention placed on contract administration. Some call it contract management, although there's little differences there. We're going to take a few minutes to talk about one particular issue in contract administration, and that's waiver. Most contract administration issues are going to arise out of or be resolved by specific language in the contract. So it's hard to generalize. There's a few common themes. We'll hit a few of those in the next few minutes in the context of waivers. But waiver is one predominant issue that is actually fairly common in terms of the way it's resolved in much of the law. This is the definition out of the NIGP Dictionary of Procurement Terms. It's fundamentally, a waiver is an intentional or voluntary relinquishment of a known right. And some of the examples are given here. The contract administration text gives a few more on pages 144 and 145. For example, if you approve a schedule that is really not consistent with the contract and the contractor relies on that and moves forward, that can be a waiver. Other requirements are similar, although deliveries of non-conforming goods or services, the right to inspect and reject, that typically is resolved under other clauses. Under the Uniform Commercial Code, if you've taken legal aspects, you'll learn that there is a right after acceptance for a reasonable amount of time to reject goods that are non-conforming if they were really difficult to discover. And in some service contracts, you'll see that also under a principle called latent defects. So we're going to talk here really on the ones that you see usually resolved through waiver law, and that has to do with schedules or other things that are bound by time constraints. There's a competing doctrine that's also defined in the NIGP dictionary that's known as estoppel. And if on the example that I gave you in terms of approving a schedule that then the contractor relies on, that's a good example, because the estoppel principle prevents really a person from taking a position that another person's relied on, the concept of reliance, if that would really be unjust. So what we're going to do now is cover three things. One is a few clauses that really affect this. Talk about what you do if you actually do waive a schedule. I mean, is it gone forever? You've got no ability then to enforce any kind of time constraints on an agreement? Well, the answer is no, and we'll explain how you do that. And then finally, we're going to talk a little bit about probably the most important thing is what do you do up front to prevent a waiver of a schedule or other requirement? I'm going to turn off the talking head video here a little bit because we've got some graphical representations of the contents here. So let's talk about some other clauses. One that you'll see in a contract often is something called the no waiver clause. And it seems like it's fairly simple. It essentially says that no requirement in the contract shall be waived through action or inaction by either party unless such a waiver is memorialized in writing. It seems like it'd be easy, but it is rather difficult because it's a contract requirement too, and it could be waived. Time of the essence clauses are those in contracts that get around the idea of immaterial breach. There can be an argument that without that clause, that if you're just a little bit late, that you've still substantially performed and there's no right to terminate for default. Well, the time of the essence clause is put in contracts sometimes to avoid that result, but it can be waived also through a succession of acceptance of late performance. Or if the final time goes by and you don't, for a reasonable amount of time, exercise your default or your termination remedies. Force majeure is a clause that gives contractors a right to additional time for some kinds of delays. On construction, sometimes it's unusually severe weather. War is one. The Katrina hurricane was an example of how that clause works in many contracts because it's, it's a hurricane. You need more time. So the force majeure clause excuses some delays so that if you're ever thinking of a termination, you've got to take that into account before you exercise it. A default clause has a similar provision as a force majeure, which is there is some excusable delay often in a default clause, notably in the federal termination for default clause. That's where the force majeure is. So be aware of the existence of those provisions along with the changes clause. If you change a provision either directly through an amendment or through a concept known as constructive change, where somebody with authority essentially informally changes a requirement, or through a contract interpretation that's overly strict or inconsistent with the contract requirements, forces the contractor to do more work, not only do they get an equitable adjustment in price if they're entitled, they also get more time. So be aware that there are clauses that affect this whole waiver thing, because the waiver is tied to these remedial provisions and requirements, and the amount of time that a contractor has is going to affect the kinds of remedies that you can exercise. So be aware of that. Well, let's say you have let the schedule go. We had a Veterans Administration construction project here in Denver. Finally finished, I think, about a year ago, but it was over $1 billion in extra costs. The schedule was busted, and I would say that probably more than 50% of construction projects are late. Well, that means that a schedule has either been mutually agreed to, or worse, it's just not been enforced. The best way to handle that is with a bilateral amendment, because a contractor may have claims for delay that's associated with the exceeding of a performance requirement, or the time requirement, the time that performance is supposed to be due. And you can talk about the waiver issue if you sit on and allow that to go by, but if there are other claims, then that ought to be resolved in an amendment that resets the schedule with your attorney's help, and then works in delay language or settlement language to take care of some of those other force majeure changes provisions that often happen. But you don't have to have a bilateral agreement. If a contractor is unhappy with what you've offered with respect to an amendment in terms of, let's say there's costs involved also, or price adjustments, but also schedule, they may refuse to assign. And in that case, you can set through a direction a unilateral schedule, reset it. But here's the deal. You can't go back and say, you busted the schedule, we're going to terminate you for default since you didn't agree to our amendment. You have to really base that unilateral adjustment on existing conditions, where they are now in the project, what the likelihood or the expected amount of performance period is required to finish, whether they are entitled to further delays, under the force majeure or the changes clause. All of that has to be rolled in when you would make a unilateral schedule determination and then send it to the contractor. That's going to need counsel help to really work through that. Otherwise, you're in breach. And finally, all of these, get the advice of legal counsel. These are hard, and there's usually interlocking claims that have to be resolved in these kinds of issues, but they can be done, and with some careful coordination with counsel, you can get a waived schedule reestablished. So here's the most important part. How do you avoid a waiver? One, you want to go ahead and work these issues quickly. Don't just let them go by and hope they're going to go away. It never does. I mean, I've seen this on both IT performance contracts where you could tell things were in trouble. They were troubled projects. Nobody did anything to really work them quickly. Don't just file progress reports, read them. In construction, which I often hold up as really the best model for contract management. I mean, if you're doing service contracts or anything, I'd talk to your public works people, find an architect that really does a good job at this in terms of progress reports. And they'll probably tell you they control those so they get the right information in them. But when they send them to you, you need to read them, because those are going to give you hints if there are problems like waiver creeping up and it looks like we're going to have problems with milestone deliveries or even the final termination date. If you skip a milestone delivery, most people are going to recommend that if you say, okay, we get this, we're okay with this, and it looks like it's not going to compromise the project delivery date, but just to remind you that we've got a waiver provision and we're going to hold you to the final performance date. Everybody agrees, and that's helps to avoid the argument that there was a waiver of a milestone and that should have been construed as a waiver of anything in terms of timeliness. And use caution with cure letters. You know, cure letter is usually sent when there's a likelihood or a possibility that the performance is being endangered. More often in terminations for default, you use a show cause letter when it looks like you've hit a final delivery date. The show cause letter can be worked for a reasonable amount of time. I think I found a case up to 41 days where it was obvious the agency wasn't waiving. They were just trying to do some consideration of the facts surrounding the decision before they made the final decision. A cure letter, though, kind of entices performance. And so if you've got a bunch of punch list items towards the end of the performance due date on a construction contract, and you're 2 days prior, and you go back and say, we need you to cure, and it's not reasonable for them to do that based on the number of punch list items, and they rely on that letter and work and work and work for the next 3 weeks, you really are going to have difficulty going back and saying, you didn't make the original performance date, we're going to terminate you for default for schedule. So use caution with cure letters and talk to your counsel in your jurisdiction about how those are used and what the issues are. Here's the case if you want to know more, or the article if you want to know more about waiver of delivery dates. It was a 2011 case and gives a couple different examples. So I'm Richard Pennington, and that is Legally Speaking about waivers. I hope that you found something in here to make you want to go back and talk to your lawyer about. That's why I give the disclaimer here. You know, I'm not practicing any longer and I'm not your attorney, but they'd sure like to hear from you. Hope you learned something.